experience on mergers and acquisitions, competition laws, real estate transactions. And of course, we have with us our panelist, who is the General Counsel with Mindtree. We have Sonal Basu also joining the fabulous panel over here. She provides strategic advice on FCPA, GDPR, immigration compliances, M&A, government relations, as well as diversity and inclusion initiatives. And she brings a vast negotiation experience with global customers and has rich experience in handling multi-million IT deals and strategic global alliances. So with that, it's time to have all of our speakers here. Looks like they're all here on the grid, all set. And with that, I'm going to request Jyoti to please initiate the proceedings of the panel. So over to you, ma'am.
Thank you, Kavya. Can everyone hear me?
Yes.
Okay, great. Okay, so thank you, Akriti, thank you, Legal Era, for inviting me to moderate this panel. And also thank you to all the panelists and to everyone who has made time to dial in to this discussion. We look forward to an interactive discussion with all of you. So let me start. And, I think now it's going to be, close to 2 quarters since the pandemic hit us. Many industries across a wide spectrum have been impacted, starting from aviation, hospitality, various others, I think, which are small SMEs as well as individuals, sports, travel, all of that. And all of this, have been hugely impacted by the pandemic, and companies are really reeling under the pressure to maintain business operations as usual. The rapid spread of the pandemic has created a situation where parties are really unable to keep up with their obligations or their contractual obligations. And this could be for various reasons. It could be, just the government regulations, the various travel restrictions, infrastructure, ports, terminals, offices have been closed, just quarantine rules, everything put together, I think has created a situation where we are forced to scrutinize the contracts very closely, look at all our rights, liabilities, obligations. Which then brings me to the topic that we are talking about today, which is force majeure. Now, if I look back many years back, I think the last I ever analyzed, honestly, this clause force majeure was when I was studying law. And that was like as long back as that. After that, I never really felt, the need. And yes, one has referred to it off and on, etc., but really not in the way that it's been referred to today. It was more of a relatively esoteric area, which after college you really didn't look at. But today, lawyers as well as non-lawyers are talking about force majeure. It's like a very popular topic. It means in French, superior force, right? Or more commonly known as the act of God. And it's sort of a doctrine that forces both parties to relook at their obligations under a contract. And it refers to the impossibility of performance resulting from the happening of an unforeseen event. This is just to put it very simply. So, all of us, and this brings me to the first question of the discussion, all of us have, in the last few months, had a rough and tough patch in every way, right? Whether it's an individual, whether it is a small business, whether it's a large business, whether it's sales, operations, risk, legal, everybody has had it very, very different, in addition to the regular routine work. I think so. The first question really is, what's your experience? How has the operational aspects of the COVID-19 impact unfolded for you in your business? How did you contribute? And how did you ensure that the customer as well as your business interests are safeguarded? So, and we have risk, we have Bala from the risk side, we have the rest of the lawyers from different industries. So if I can start with, say, Neha, it would be really nice to know what is it that you did, and how did you react, and what are the few things that you would like to share with us as the immediate practices that you put into place when this hit us?
Sure. Thanks, Jyoti. Good morning, everyone. So luckily for us, I would say that the experience of transitioning from a pre-pandemic to a post-pandemic regulation and ways of working was not too much of a challenge because we are, a company that's touting digital transformation. So we are sort of already leading by example. We're already there. So in that sense, just transitioning in terms of work for us as a personal experience was not difficult. Of course, it's a whole another story that you are constantly working from home, which was a challenge. Now, for me personally, I represent the compliance organization from SAP, and ours is an international organization. We're like a mini United Nations when we all get together under one roof, which we were supposed to this year, but we couldn't because of the pandemic. So, in that sense, it was not too much of a challenge. But in doing our work as a compliance team, there are certain checks and balances, certain activities that we have to perform as part of our promise to our customers and to our board members, to our commitment in the market. Things like due diligence, which have to be done, which got frustrated during this pandemic time because certain things have to be done in physical presence. They are physical activities. Now, that is the area where we face challenge. And to be honest, because there is no light at the end of the tunnel, at least for our market unit, the way the pandemic is going ahead in India, there's no way to fathom when this is going to end. For the time being, we have told our vendors who are supposed to perform certain physical obligations that we will put this on hold. So approvals, for instance, internal approvals that are given based on certain checks have to be now moved to conditional approvals until such time that the pandemic is over. So it has impacted us. It has not impacted us. One thing I can say for sure, because I'm consistently working with people around the world, that it has affected everybody, every single nation, even the ones that thought that they had it under control, whether it's New Zealand or South Korea, they are seeing outbursts again. So it's a very volatile time. We have to be agile. Agile mindset is absolutely, the top agenda. And yeah, that's been my experience.
Okay, so Sonal, tell us about Mindtree. I know that the IT industry is probably not as impacted, but at the same time, I know that there was complete chaos when it happened, right? In terms of how do we strike that balance that we are talking about. What are the few things? How does this whole thing sort of unfold for Mindtree and for you as the lawyer heading the legal team of that company?
Thanks, Jyoti. It's been interesting times is what I would like to start with, and good morning all. I think what we did as a first thing was setting up a task force. We did that early on because we are in the IT space, and IT is the backbone for most of our clients across all the industries. So that task force really helped in terms of planning every step ahead, right? We also focused on having a very close connect with three main set of people. One is the client, second is our employees, and third is the IT arm, right? So there was constant communication between these three set of people because they were the backbone of running everything as is and not disrupting. The other thing that I would say is from an operational standpoint, because we also had to safeguard clients' interests and our interests. So we made sure that we, created an enhanced level of awareness in terms of compliance with client policies, internal policies, confidentiality, InfoSec, because that was the main thing. We worked on additional undertakings, reiterating their obligations. We also reminded employees of respecting the space when you are in digital space of employees from a posh standpoint. Because everyone forgot that there are other things as well which are extremely important. Just because you're on a video call does not mean that you can start behaving the way you want to behave, right? So we focused on those nuances as well. But net what I can tell you is collaboration played an important role. Clients really appreciated the fact that we were proactive. We were collaborative. We gave them the comfort from an IT standpoint about what they could or couldn't do and what would help them mitigate their risks from Infosys standpoint. So all these things did help.
And from a force major perspective, I mean, what is it that, some of the customers, some of the changes that you had to sort of make because this event had happened? Is there something that comes to the mind?
Yes, so I think most of the clients, at least I can talk about my company, didn't want to pull the plug. They themselves were exploring, right, what was happening.
Yeah.
They weren't very sure what was going to happen, and this was somewhere around March, April. So they wanted to take the collaborative route, which is what they did. Of course, there were some concessions which were requested on the commercial front, saying, slightly elongated credit period or a bit of discount, slight minor ramp downs, but it was all collaborative. They also didn't want to exercise force majeure clause because then the window starts ticking. They couldn't have blamed us or even taken the blame themselves because all of us were sailing the same boat.
Right.
So they did have a very, I would say, they took a collaborative approach saying, here we are in this state, let's just talk and see how we can work around this. And it worked.
Okay, great. So Bala, we've heard two lawyers. I think it'll be great to understand the risk perspective. How did you deal with something like this, more from a force majeure angle, of course?
Yeah, I mean, force majeure, we know what it means. I mean, typically, it doesn't being covered under civil law, but it again depends on what exactly you capture in your contract. That is where what are the force majeure events. So, as a typical part of our continuous risk monitoring process, when this happened, we flagged it up saying that there is a potential scenario where customers can invoke, because at that point in time, March, I think April, it was not global per se, but it was few concentrated points like, we had Italy and we had France, Spain coming up, and there were pockets which was coming up pretty dense. So US was not so much at that point in time. So we were like, reviewing as a risk, and we said we need to look at, the contracts which has got, typically we follow the 80-20 principle, which is who's giving 80% of the business from 20% of the customers, right?
Yeah.
So 20% of the contracts are more important, and we had to go through the 20% of the contracts on what exactly have we captured and agreed on a force majeure clause. And flip side, jurisdiction is also not India, so that's another spin to the entire thought process. So we had to look at the different jurisdictions and what FM means there, and how it is applicable, and what are the brackets available where we can avail certain things. So that was one very intensive exercise, and that is when we proactively, as Sonal rightly mentioned, typically we focused on the 20% of the customers where we didn't want to give an opportunity to the customer to even think about a force majeure clause, and that is when we ramped up. While we had typical scenarios where even though you have invoked and people are remotely working, and there's a power cut. Not everybody lives in a flamboyant society where they've got a power gen to back up and everything. So then your laptop gives you at best about an hour or two, and beyond which they are offline. So a lot of tactical strategies were put in place to look at the consumption. Nobody even thought about the dongles which has been issued to people. It comes with a 1 GB daily limit. Right. So on a day-to-day usage, you don't even see that. But the moment you work 100% work from home, your 1 GB goes up in less than about 2-3 hours. Then what happens? So we had to talk to the ISPs. I mean, there were too many fronts where, as Neha rightly pointed out, it was a complete, macro situation. But one thing that brought everyone to the common stage was everybody wanted to take this forward and not talk about force majeure. And I think that was a very welcoming decision by most of the people, even though government did talk about it. But I think that paved a lot of way in having a more constructive discussion with each stakeholder in the entire service delivery process. And like Sonal said, we have multiple functions, right? So all the functions came together from our side, from the customer side, from our supplier end, and we were able to collaboratively take this to the next level because everybody wanted to make it happen rather than just pull the plug. So I would say yes, that was a very rich learning for every one of us.
So what you say, you make an interesting point that, what comes out of this whole thing is that so important to have a repository, right? So it's like last minute, you can't be scrambling around looking for contracts. So while some are in the stage of developing one, some are already developed, overall, not only repository, but also become very important to have a good analytics AI tool to be able to then go through the contracts and say, hey, this is the contract with the force majeure clause, this one didn't have it, this one had pandemic, this one didn't have it, etc., etc. So it does become important. I think the other thing, that sort of becomes very important is a lot of things Sonal mentioned, that there were changes in, say termination or in payment terms or any of that. What then becomes important is that, how do you then change the contract given that nobody can meet each other? So how are you going to make sure that it's agreed in writing, but it's not really in writing, right? So the email enforceability then also becomes important, across different jurisdictions. I remember in Infosys, we took, opinions across some 15 jurisdictions just to know for sure that what we're doing is correct. So let's ask Mr. Sachdeva now what's been his experience. He's also leading in a very large conglomerate. What's been your experience, Mr. Sachdeva? If you can share some of your immediate reactions to COVID-19 and how you've coped with it in the last few months.
Yeah, thank you, Jyoti. And
put your camera, I think we can't hear.
I'm audible, I believe. The bandwidth was little.
We can hear you. We can't see you though.
Okay. We also, as Sonal and Neha mentioned, we created a task force when this COVID-19 started sometimes in mid-March. So the business teams, in collaboration with the legal teams, they were analyzing the impact of COVID-19, in particular reference to the FM clause. Debate was also on if FM clause is not there, can we invoke doctrine of frustration? So while the debate, and I remember in March, the entire emphasis or the edifice was if there is no force majeure clause, please go and invoke doctrine of frustration. Yeah. And I think most of the law firms, and I will not say here, most of the law firms also went on to say, let's analyze if a force majeure clause is not there, please go and take the recourse under doctrine of frustration. Now, the issues which were being created in our system was, how do we go about what is the interplay between doctrine of frustration and force majeure, and what would be the consequences? And I'll not go into the specifics. Typically, we analyzed various force majeure clauses, and the consequences were different because in different jurisdictions there were different clauses. Somewhere force majeure clauses were only referring to suspension or delay. Somewhere there was a right to termination available after a specified period, let's say 3 months, 4 months. Somewhere there were excuse for performance permanently. So every business, since it's a large group, we have a tire business, we have paper, we have cement, we have other businesses. Every business has its own nuances. So there was no particular set rule or thumb rule that we will take a view if there is a suspension, how it has to be dealt with. Ultimately, it was being seen in the context that we should have a collaborative approach. In the sense, we should go for a mitigation of risk. We go for continuation or resumption of business, and that was the key aspect. Now, on doctrine of frustration, at least the legal point and our view was clear. The consequences of invocation of doctrine of frustration, as it is there under Section 56 of the Indian Contract Act, this would mean status quo ante. And let's say a lease agreement, typically people said, since we don't have a clause of force majeure clause in the lease agreement, can we invoke doctrine of frustration? Now, issue was some of our offices have leases. That would typically mean leases the lessee will have to let go of the possession. That means the lease is getting terminated. So people in certain jurisdictions, certain cases, they relied upon doctrine of frustration, but then the consequences were then they were to leave those premises and hand it over to the lessor, which I think was not the key aspect when we were taking a call on the issue whether force majeure clause should be invoked or doctrine of frustration should be invoked. So with that, I think analysis was done contract-wise, business-wise, and also looking at the collaborative approach, which was the key. And I think we succeeded in most of the cases. In the sense, we never went for a litigation. We had a collaborative approach. In most of the time, it was give and take. In certain cases, we are also landlords, and we have leased out our buildings and premises in other Calcutta and Bombay, etc. So we were wary of the fact if tomorrow we ask the lessee to pay the rent and he vacates, whether we will be able to find another tenant on the same terms and conditions. Maybe this is something where 3 months we can take a hit or we can decide. In other cases, we were the tenants and we were occupying as a tenant, and lease agreement had a force majeure clause, but then it had certain nuances. So net, it was a collaborative approach. There was no thumb rule being seen or followed, unlike, normally if you are working in a pharma industry or you're working in IT industry, you issue a direction, and those directions become SOP and then guidelines, and people implement it. But in our case, position was quite different.
Okay. Thanks, Mr. Sachdeva. I think let's hear Vinod, and what is his view and what did he do when this, pandemic hit us, and how did a business like his react, and how did you manage it, Vinod? What was your experience?
Sure. Thanks, Jyoti. So when the pandemic started becoming a very global, widespread event, the first point that we were discussing is let's look at all our contracts and see where force majeures can be invoked. And we were preparing our force majeure notification to all our customers across the globe, whether it's US, UK, Canada, or Australia. So we were preparing there was discussion on should we go very specific into each contract to notify force majeure, or should we do a very generic template-based notification? Because if it was going to be very specific to each contract, we are going to talk about some 200, 300 contracts,
right,
and customized notification. So we took an approach. Let's set it from an ultimate parent entity and cover affiliates through it, and let it go as a notification. And it is not very legalese. It is more like a corporate communication, and that's how we notified. The interesting portion is not when we notified the customers. The interesting portion was when the customer came back and said, we do not agree to what you are notifying. And post which we had conversation with the customer said, see, honestly, our response to you was a template-based response because we are getting so many notifications ourselves. So they were preparing a standard response to all such force majeure notifications. So the world was going template-based notifications of force majeure as well as responses, which was very interesting. That was the experience for us for the last 2 quarters at least.
Right.
And I'd also like to narrate something that was very personal and very retail. So I had engaged a third party, a professional broking agency to find tenant for my apartment. And the deal contract was if the tenant is not found within 60 days, they would refund the entire service fee. Now, within 60 days, they could not find a tenant. Or when the tenant was readily available to do a house visit, the entire area was under lockdown or containment zone. And the tenant could not visit it. The tenant moved on. The potential tenant moved on, and therefore there was no contract. So when I had a conversation with the broking agency, they said force majeure. So it was an interesting conversation. So I thought of taking them to the consumer court, but my contacts in the legal field also said the courts are not functioning either. It's force majeure there too. So it was it was force majeure all across in all fields. It was a very interesting experience for the last 2 quarters.
Thanks, Vinod. Thanks. It's interesting you talk about notifications. I think we did the same. We had 2-3 different formats, and we thought we were, it was a sort of, you're right, it was more like a communication and less of a legal communication. But like you, we also had a lot of pushback from customers. And I think the important thing was to make the customer, see, our contracts did not say work from home allowed at any point, right? So, and this was suddenly a work from home. So customer consent became extremely important. The other thing is force majeure also talks about BCP. It says that, all right, if things go wrong and, you didn't know anything, then within a certain period of time, your BCP will come into play. That means if one branch is down, another will start. If one country is down, the other country branch will pick up. Here, none of that happened. Everything from branch to country to everything was gone, right? So very unusual, very unusual. But, that takes us to the next question as to what if a customer did not have a clause? What happens to the individuals, right, who probably don't either have a contract or don't have, or just have a letter of engagement, or the contract clause or the FM clause is missing? What happens in situations like this? COVID-19, either ways, even if you have a contract with the FM clause, with everything put in, pandemic included, it's been around for a while now. So in today's situation, can you really say that, hey, I'm getting the benefit of COVID-19 or the force majeure clause per se? Is that something you see happening? I think, Vinod, we'll go backwards now. We'll start with you again. Do you think that we can say force majeure and take some, benefit of the clause anymore? Having said that, it's been around for a while in that context.
In that context, I think we just need to relook at what force majeure means. The force majeure's one of the fundamental, essential element is the event should be unforeseen. And today we are in a world where it's called technically the new normal. And a pandemic of the size and scale of COVID-19 is considered foreseen. It's not no more unforeseen. While it may impact individual resources and therefore consequential non-availability of resources, employees not coming to office or suppliers are not available or the supplier's employees are affected, those are all possibilities. But with the right business continuity plan, they should be able to cope up with it. The suppliers or service providers or whoever it is, they should be able to cope up and provide a plan B. If person A is not available, can it be done through person B? And that, I think, also defines the other element of force majeure. What is your mitigation plan to overcome the force majeure? Because courts will definitely see not only the force majeure event, but what did you do to overcome it? So with that element, we should also be careful. We cannot no longer blindly invoke force majeure, but we should also say we took steps to mitigate our risks. We took steps to find alternatives. Despite all that, we are unable to do. Therefore, a force majeure. That's when force majeure comes, and not at the first place. That's my view.
Sonal, what about you? What's your view on this?
I have a slightly different approach. I think it's impossible to pen down everything in your contract. I mean, today it's pandemic, tomorrow it could be something else. We should take an approach where, you should have either a material adverse change kind of provision or a crisis clause, which allows parties to have a conversation and allows them to work on an amendment. And I've seen that, with a lot of global clients, they have also started adopting this measure where they're saying, okay, it's different times. You have said that you would be operating from XYZ locations, but that's changing now. So can we look at an amendment where we both talk and iron out what is the most feasible option to continue? Because nobody wants disruption, right? So that's one. And secondly, one should remember that, it's okay to leverage your force majeure clause if it's as clear as, pandemic, but also remember that there are two things which are extremely important. One is the clock starts ticking, right? There's always a window where parties have an obligation, as Vinod rightly mentioned, to mitigate the exposure, right? So your clock is ticking, and if you're not in a position to mitigate, then if you're a service provider, client has an option to pull the plug, and vice versa, right? Depending on how the situation is. So it's not just about having a force majeure clause in the coverage. One should also look at the pragmatic nuances vis-a-vis that. So that's how I would put it. I think lawyers should look at contracts with a different lens going forward, not just look at force majeure, try and see how we could mitigate the exposure from a commercial standpoint. And I think that's what matters at the end of the day, be it on the buy side or the sell side.
Right. Mr.
I'll
Sachdeva.
just add a very small point to what Sonal mentioned. You may do more harm to yourself by invoking force majeure, because force majeure can result in termination of the contract.
Absolutely.
So you may end up doing more harm by invoking force majeure than by doing a risk mitigation activity.
So it's interesting, right? No one really used the force majeure clause or could not use it, but it's the most talked about topic.
Yes.
So, yeah. Okay, Mr. Sachdeva, what are your views, especially around the doctrine of frustration you mentioned before? I mean, can that really be utilized by a customer who didn't have a clause?
So let me just go back to I'll cite 3 or 4 legal cases, 3 for the Indian context, 3 from the US context, and then maybe we can debate upon this issue in a larger perspective. See, in the Delhi High Court, one of the issues was debated whether lockdown entitles tenants to seek suspension of rent. Justice Pratibha Singh came out with a judgment sometime in May this year, and she interpreted first Section 56, which we have been talking about, doctrine of frustration. It doesn't apply to tenancies, and she relied upon the earlier cases and said Section 56 is no recourse when you are talking about a landlord-tenant dispute. Parties can go and agitate this issue either if they have a FM clause or by virtue of Transfer of Property Act, which governs the leases.
Right.
And she also made an interesting observation, since in this particular case, this was Ramanan versus Girish Soni, Delhi High Court. She also made an observation, since there was no rent agreement or lease between landlord and tenant, therefore the tenant could not even rely upon Section 32 of the Contract Act, and therefore force majeure clause was also not applicable. Third, she said, from the evidence, since tenants do not intend to surrender the lease premises, and in that case, tenant even cannot claim suspension of rent. So these were the observations given by the Delhi High Court. The Bombay High Court in Standard Retail versus GS Global came out another interesting observation. There was a Section 9 application filed by the Indian company against a Korean company seeking directions restraining the bank from encashing the letter of credit provided to the Korean-based exporter, claiming that lockdown had rendered performance of the contract impossible. So Bombay High Court rejected this, saying one, the import, whatever obligations were there, those have already been fulfilled. Import has already been allowed. As per the Contract Act, the goods had already been shipped. Therefore, they rejected this force majeure clause, and they said that force majeure clause does not give them the benefit to seek an injunction under Section 9. Third, which is again Delhi High Court case, Halliburton Offshore versus Vedanta, a very interesting case where contractor Halliburton, they were given certain contracts to fulfill their obligations within 12 months, 24 months, and something like that. But they sought an extension. In fact, the original dates were where they were to complete this contracts 25th November 2019. They were to close this. But they sought an extension and cure plans were given. As per the revised plan, one of the date was 31st March 2020. But when the Vedanta wanted to encash the bank guarantee because of non-performance on the part of this Halliburton, initially Delhi High Court granted an interim order of stay. But later that was vacated on the facts that substantial work which was required to be completed by the contractor was not done. In fact, 31st March 2020 was the end date, and the court found that even from 1st March to 31st March 2020, there was a lot of work which was pending. So court made an observation. One, the contractor was not performing his part of the obligation under the contract. The court also made an observation which is quite interesting, that force majeure clause is to be interpreted narrowly and not broadly. It is a narrow interpretation which courts have been taking in Indian context, and therefore broad interpretation is not allowed. And thirdly, they said we cannot justify a non-performance and give a shelter to the contractor by invoking a force majeure clause or doctrine of frustration. So these three cases, I think, set the ball in motion when, and I think Sonal touched upon this aspect, people or the companies were not interested to go and litigate based on the force majeure clause. I think this was more of a collaborative approach which people took it. If time permits, I can cite those US cases also, but I know other panelists are waiting. So maybe these are the three cases which I could find out from the Delhi High Court and Bombay High Court. But if you want, I can go on for the US cases also where similar position exists. I'm not able to hear you, Jyoti. You're on mute.
Sorry. Yeah. No, I think that was very useful. I think both the case law perspective on this whole thing was definitely added a lot of value to the discussion.
Maybe in US context, I can give you one particular case. This is Argon energy case. And that was in relation to the energy supplied. They were supplying natural gas to Argon.
Right.
They had a contract which stated that party may invoke force majeure, and if that party has not remedied with all reasonable dispatch. During this Hurricane Katrina, which caused extensive damage to the gas industry's infrastructure, the force majeure clause was invoked. So, when matter went to the court, the US court said they held that the supplier had the right to declare the force majeure, and they were rightly claiming the force majeure clause. That's the US position. I'll come to the another one, which is again avian flu case. Avian flu case. There was a producer of the egg products. He wanted to expand its business operations and egg processing plant. He had planned to build up a new egg processing plant, for which he needed some industrial egg dryer for the new plant. Now he entered into a contract with the manufacturer supplier to give him the new egg processing dryer. But what happened in between, the avian flu started. So he discontinued his expansion plan and invoked the force majeure. Court did not allow him to invoke the force majeure clause. They said supplier or manufacturer, he was not aware of the principal purpose of the contract, whether it was for expansion or it was for the existing unit. So court rejected. So there are instances. I think that's what I could make out. Maybe the other panelists can add on to these issues.
Yeah, thanks. I think I'll go to Neha. Neha, you'll have to unmute. Tell us about your experience in SAP.
Yeah, sure. So I think my co-panelists have shared varied experience, but for the force majeure clause, I'll probably rely on me as a drafting lawyer who put in force majeure clauses into contracts for so many years. And like you said, Jyoti, never thinking about the clause per se. It was never front and center. It was one of those clauses, bucket list clauses that you just put towards the end after you've done sort of the main chunk of the negotiation. I also remember, oftentimes looking at force majeure clauses, reading words such as pandemic, epidemic, and wondering, does this even apply to us? Because our generation hasn't experienced it, right? So it was absolutely irrelevant in my eyes. I said, this is something that we've inherited, and it's against simplification. I don't know why we have it.
Yeah.
Yeah, exactly. But now, I mean, how are we learning? It's unrealistic. I mean, really, when I think of, and in my head, when I thought of act of God, I thought of as one event. It could be a forest fire, it could be a cyclone somewhere. It was one act. It was typically restricted to one geography, and probably had a limited time period, and so on and so forth. But I think that this pandemic has turned the whole concept of how we write force majeure on its head, because one is the act. It's not just limited to act of God, which is the virus itself and the way it infects humans, but it's also got other elements or other events that are defined in a typical force majeure which it attracts. So first it was the epidemic. It was an epidemic, then it was a pandemic, and then it was the government restrictions, which is also typically defined as a separate event in a force majeure clause. But we have this, all of it happening together in one go. Added to that, I think there are complications, such as I think the world is more connected than ever before. And we are relying more and more on other countries, etc. So with the shutdown of borders, you have that additional pressure of, how do you interpret the sort of girth of this situation, right? Of the pandemic, and also I think for us, some of the services companies, perhaps it is for the first time, perhaps considering from a labor perspective. So from an employee's perspective, are they comfortable to go and to perform the services? So I remember during sort of the very early days, we had certain requests, and most of our work actually happens online, luckily. But we have these requests for certain experts, for instance, to go into certain projects which are not on the cloud, but which are on-premise projects, which are probably, they have an element of privacy, secrecy, etc. And we had such difficulty extracting and getting consent of an employee to actually travel during that time. So managing so many different elements. So your initial question was, force majeure clause can be invoked, will it apply? I think short answer to, and I actually gave a very long answer, but the short answer would be, I think, how you drafted the clause. And most of the times we didn't put in any thought into what clause we have in the contract. But we are stuck with whatever we agreed to at this point in time. But this experience is going to lead to a lot of creative input, insight, evolution of this clause. I think it's in focus, so it's going to evolve going forward for sure.
No, that's absolutely correct.
And Jyoti, I would just like to add to what Sachdeva and Neha mentioned. In addition to all the brilliant case laws that Sachdeva mentioned, there is one more which is very important in this scenario. In 2017, there was an energy watchdog case passed by the Supreme Court. A judgment was passed by the Supreme Court where an 11-point agenda was given by the Supreme Court to determine force majeure. So if those 11 points are satisfied, then a force majeure is deemed applicable. And one of the points that they have mentioned there is something which is very relevant in the current scenario is I can just read it out now. It says, performance is not discharged simply if it becomes onerous between the parties. So if something is onerous, then it doesn't mean force majeure. Or rather, a force majeure, to remediate a force majeure, you cannot seek excuse under the guard that it is onerous on me. The reason why I'm stating this is in contrast with what is prevalently seen in the US contracts, where commercially reasonable efforts can be considered to seek guard against remediation activities. If the remediation is so onerous that it is not commercially reasonable, you can still seek an excuse, and that is applicable under the US laws. But in the Indian context, it says onerous is not an excuse at all. You still have to do the performance of the contract. So I think this is a very brilliant judgment as well.
Yes,
just to add what Vinod said, I think Energy Watchdog, they rejected the contention because contention was being taken for a rise in price of coal, then they apply doctrine of frustration. So Justice Remington Nariman clearly said, if there's a price rise of coal and those price was not contemplated under the clause, doctrine of frustration will not apply. So he rejected. So typically the interpretation in Indian context has been that doctrine of frustration or force majeure clause should be narrowly interpreted. And what Neha said, I think, is again ICC, after this COVID, they amended their force majeure clause. You please download the force majeure clause. Now they have added pandemic, COVID, everything, and clause has been much more widened in terms of the interpretation and how it has to be seen. The notice clause also. So typically when these kind of things happen, ICC and other, those, they amend those clauses. So which means you have to interpret in the sense, what is the clause all about? If the clause is not having those events, it's a situation where interpretation can go either way.
Yeah, so I think now I see Kavya. I think we're probably running out of time. Just want to take a quick check on that, Kavya.
Yes, Jyoti. So we have another last 3 minutes left for the panel.
Do you want, is there time for a Q&A, or can I just continue and...
I believe in the discuss box, as of now, we have not received any Q&A, so I'm just going to urge all the audience members, in case you want to pose your questions, please do quickly drop it so that Jyoti and the rest of the panelists can answer it. Until then, you can continue, Jyoti.
Yeah, sure. So I think the last thing we had really was, it'll be interesting for us to share some learnings with the people who have dialed in with each other also. So, what kind of changes do you really foresee in the future when it comes to a commercial negotiation or the clauses in a contract? We can start with, anyone. I think, Sonal, why don't you start on this one?
Sure. So I guess there are a lot of learnings for all the lawyers. The first learning is digress from indemnities and liabilities alone. Focus, always take a business view of the, we all are commercial lawyers, right? We are business enablers. So always take a holistic view in terms of how would you safeguard your interests from a commercial standpoint for your organization. Focus on clauses which are beyond force majeure, like a crisis clause or a material adverse change clause. Try and include provisions where there's a window to have a conversation which allows you to execute CR, because I don't think it's in the interest of either party just to pull the plug and sever the relationship. So learnings are, look at your contract slightly differently, try and include clauses which would be in the interest of both the parties and which are sustainable.
Right. How about you, Bala? From a risk perspective, again, you bring a completely different perspective to this. So if you can quickly tell us. Okay, I think he's dropped off. Vinod, what about you?
From a risk perspective, you just need to highlight in your contracts, firstly, understand what will be the governing law and jurisdiction of the contract, because that is going to significantly determine how force majeure is going to be separated.
Yeah. No, it was just more on learnings, actually. Anything, Neha, Mr. Sachdeva, anything on...
Let me add to what I think we did not debate on the JV issue. And all of us know joint ventures, when they are executed, normally you have a clause that certain projections, business projections, etc., will be approved by both the JV partners. Now, we are facing situations, and I'm talking from the Indian perspective, where Indian companies have a JV with a foreign collaborator or foreign partner, and decision-making process in these testing times becomes difficult because you can't give a plan and budget. You don't know how this plan and budget will be so much weight. So this could trigger a deadlock. Deadlock means when under the JV agreement, 50-50 controlled by both Indian party and the foreign party, and foreign party has a right to walk out in case, the deadlock is not resolved or the parties are not back to their own original way of carrying on with the company. In that case, I think I could see next year, 2021, hopefully, if things are sorted out fine. Otherwise, there will be issues on joint ventures when parties will be either asking for, exit or buyout procedures will be there. We don't know. That is yet to be tested. I've not seen any any of those issues coming to the court, but I think next year that may crop up.
Okay. Neha, any last comments from you?
Yeah, and I'll be quick. I know we're almost out of time. I think some of the major learnings are going to be for, from an in-house business lawyer perspective, to look at your force majeure clause again, check what how the language needs to be updated out of the learnings that we've had. Also have revised strategies on how you respond to negotiation, to force majeure clause during negotiations, reprioritize some of the things. And I think most importantly, figure out practical ways of the remedies section that you have. They have to be workable remedies. They have to make sense. And like Sonal said, I think it's, we are evolving in the sense that we are business lawyers. We have to think of not how we protect ourselves in a force majeure clause alone, but also how we will move forward and how we're able to cross the hurdle, how we as lawyers can grow, in the same direction as the business, as the delivery, all in the direction of getting success out of the contract. I think that's going to be important, and I think that those would be my sort of last comments.
Yeah, and Jyoti, just one more point. I think all of us should also focus on informal dispute resolution followed by mediation, so that people don't take extreme steps and try and salvage the situation through that route.
Yeah, and working from home is, you're also not working in the same control environment. So somewhere the contracts and the customers need to sort of have a clause wherein parties can work together to come to a resolution in case of an issue. And it's not the same. It's not an ODC setup anymore, right? So there is a change in that. But yes, thank you so much. I can see Kavya back again. We are at the end of the discussion. Thank you to the panelists and everyone who dialed in. Thank you so much. It's been a great discussion.
Thank you everyone. Thank you, Jyoti, for being a moderator for this lovely session. Thank you. Thank you, everyone.
Thank you, everyone.
Thank you, everyone, and thank you very much.